Before we move away from the market-based sourcing regs, because I hear you with respect to the fact that the FTB might feel a little burned because they put out the, PAM and um, publication about PLD 6272, and so they, may not want to put out a lot about the market-based sourcing rules, but the hearing is the end of January, and then what's the process after that?
Well, it could go a variety of ways. My suspicion is they're going to just proceed to the Office of Administrative Law and get them final, and it'll be done. And these will be the regs we'll be stuck with for another 10 years. And I suspect within a year or so, there's going to be another interested parties meeting to suggest some amendments to it because, it's really difficult to apply these things just statically in the world we know now. But, advances in technology, the way things change, how business gets done, changing, it's going to be constant sort of reevaluation and trying to get some guidance for people to figure out how to comply. What is the right way to comply? It seems like there's a lot of
Right.
gray area.
Sure. Yeah, I think that the point, right, of those regulations is to try to give guidance, but it's a lot of information and they can't anticipate everything.
It's almost like they tried to, and then they said, never mind, we're not going to be able to. If you look at how many examples they have,
Yes.
there's so
Yes.
many examples and they're not always consistent. And it's like, well, in that example, you said this. In this
Mm.
example, even though it's different, you say this.
I know. It's as a practitioner with lots of service-based companies, we really have to pour through those and just make sure that we understand how our clients' facts might fit into an example or 2 or 3, in those
And
regs.
sometimes you need just like kind of a conspiracy theory board of like, here's a picture with all the red string linked because it's like, well, if the facts are the same in example 4, but for this piece in example 5, and now we're in example 10, and you're like, I'm sorry, where are we? And like, what are our actual facts that we're trying to outline? Some examples in any reg are just sometimes not good. They're not
I
well
there's
written.
there's going to be a new episode to CSI.
Right.
CSI, the benefit of the service.
There you go. There you go. I like it. I like
That's the
it.
accountant too. Think Ben Affleck can get on
There
board?
we-
The tax version.
yes, can we get a salt version of the accountant? We could get 5
There you
people to
go.
watch.
I think I
All
think
5 of our listeners. Thank you to
Yes.
our
I think
loyalists.
I think you guys might be onto something.
We're gonna claim those rights. Mike, write it up. We'll take it
My
somewhere in
next career,
Hollywood,
screenwriter,
right?
a salt screenwriter. Yes.
That's right.
So that's kind of where that's heading. So I don't do you have any more questions on that? We can always circle in and circle back to it if I think of other things, but
No, again, it was more I just thought it'd be good for the, kind of our listeners to hear about process, right? Because if anybody's been following, PLA 6272, right, there obviously wasn't the proper process,
Mhm.
right? So it was just, I think, just good to highlight kind of what is the process. And we now know with this regulation that it is in process and well has been ad nauseum, but uh, there is a process.
Yes, there is a
It's just a
process.
lengthy one, a lengthy one.
Yeah, it is. Like the staff has to get permission from the board, the franchise tax board, the actual people who are the board to proceed with this. And they got that back in 2020. And then after that, they issued these legal rulings. So it's like, hey, you know what? One of the things I said is, why don't we take a step back and kind of incorporate the legal rulings, which one is into the reg, but well, at least as of yet, haven't responded to that, and I don't think they're going to, but they have gone through the process. They're going through this last part of the process. Maybe they will go back to the drawing board and change some things. Maybe not, but we'll see. But I think they're getting close to just here's the next set of final regulations, and these will be the things that you have to apply going forward until they change it again.
Okay.
So watch out for those. Those are coming up, and that'll be for 2025.
Okay. Good to know. We might not be able to apply them, but good to know.
Yeah, here's
Or we're going to need help applying them.
Yeah, it's like, how do we apply them? And it's not like a Scantron test where there's one absolutely correct answer. But, well, maybe this,
Right.
maybe this. So you have to kind of do some weighing, balancing, and
Mm-hmm. Yep.
figuring out which is the best way to go. Also thinking about, okay, if we do it this way this year, they're going to expect us to be doing it this way next year and the next year. Doesn't mean you're necessarily stuck with it. I think I've always taken the position that a tax return can be prepared incorrectly. It doesn't mean you have to stay with an error just because you made one before. Um, they'll fight that and say, no, you're stuck with it. But if it's wrong, and you just have to correct it.
Yeah, there are federal method changes where if you have two bad things, it's now a method and you got to change that. Not really in our framework here.
Yeah,
Um,
like the one area I think about when I think about this is unity. Are you a unitary group or not? I see a lot of companies who are, during the years, their income tax is like, not a huge deal. They've got a lot of different entities, and it's just easier to file on a combined basis. And I don't know if people really examine whether there is unity or not. There's, and I've had a few clients where we just want to file all combined. We just want to file all combined. We don't want to do all these separate return states. And yeah, it's fine until you have a big sale that creates a bunch of taxable income, a giant gain. Then you're like, oh, maybe we should examine this. And perhaps maybe you weren't unitary. You got to look at the facts and apply them. And the law of unity is the law of unity. If you mess it up earlier on, you're not going to be stuck with it. You got to correct it. So here's another one that I just want to mention here because it's pretty timely, and I don't know if it's going to happen, but it's a pretty good chance. So Governor Newsom put out his it's sort of like a proposal for the budget and what kind of tweaks they've made. So California is a single sales factor state generally. However, there are certain industries that are still required to use three factor: property, payroll, and sales. If you're in financial or extractive or agricultural, and they have a whole bunch of tests for those, then you use three factor. But Newsom has suggested for financial to pull them out and have financials be single sales factor. So this would be good news for financials in California and not good news for financials outside of California. Because no longer can you rely on your payroll and property to dilute your apportionment percentage. I haven't seen anything else on it. This is pretty recent. It came out a couple days ago, so that's something to keep a lookout for.
All right. So at this point, that's just proposed,
It's
right?
just proposed. It
Okay.
is in the budget though, so it's not just like necessarily a throwaway. I think there's going to have to be some serious opposition because money talks.
One, isn't that the perfect plan where your constituents get a break, but your out of state, your non voters don't? And especially with the state of California and the size, and we're talking financial institutions and money and stuff.
That is the playbook.
Seems like the perfect resolution for, you know, fundraising
Yeah, I mean,
realistically.
that's kind of how the whole single sales factor
Yeah.
started. That, and then you're a state that, because I mean, forever ago, the Willis report times, like when the feds were like, hey, you know what? We're thinking about just taking this whole area over. And then the states were like, ooh, we don't like that. Let's create the multi-state tax commission and let's create UDIPTA and let's have everyone say we're going to accept all of these rules the same. So there's uniformity. We don't have the risk of double taxation. Look how good we're doing. And then the feds backed away. And then we had UDIPTA and three-factor formulas, a fair way to evaluate where you're doing business and where your income should be taxed. And then time passes and the threat of the feds taking over and preempting the states, and they start saying, hey, let's do single sales factor because it's like another way of doing like credits, kind of like, hey, invest in the state, we'll give you credits. Well, we don't really have to do credits if we just tweak the formula. So basically, you property and payroll, you're hiring here, you're investing in property here. We're going to take that out of the equation of how much income tax you have. And then once one state does it, then another state does it. And then you have a whole other reason why you have to do it. It's like you're not competitive anymore. And suddenly all your businesses are leaving. So you join in.
Yeah.
And that's kind of where we're at
Yeah.
now.
Yeah, well, and California was obviously a very, very early adopter of that.
Yes.
So out on the forefront.
Yep. And then New York, it's like California and New York. We watched these two states,
Yes.
and
Yep.
New York did what
That
California had done. Like New York was separate company state forever. They had some weird rules for combination, which were
Mhm.
difficult. And then they finally said, yep, single sales factor, economic nexus, and unitary combined reporting. That's profit maximizing.
All right. So, what was one of the other topics that you were going to bring up? I think before we kind of circle back and got into unity. What else? What else is occupying your time these days?
Um,
Where do you want to start?
Let me pull
yeah,
out
this
my
one is pretty.
timesheet and just really pinpoint all those real specific issues.
Well, you mentioned the reg project 17955 17951 dash 5 and 8, and this is about directors, non-residents, non-employee directors. And this is because I was thinking about this, and this is kind of emblematic of what California is doing as far as we want to get everyone to use market-based sourcing. So these regulations have been around for a while and maybe not drafted artfully, but I think the intention originally was not to say, if you're an independent contractor, you should use UDIPTA. They had rules, and if you look at the existing reg 17951 now, it's not very specific as far as being an employee. Well, what FTB wants to do, at least in their draft of their proposed regs, is to be very clear that the rules under 17951 and 17951 applies of where are you performing your services tests. So not market-based sourcing. They want to be very clear that if you're an employee, it's where you're working. But if you're an entrepreneur, you're going to go into UDIPTA. So that's kind of where they're going with that. And then their dash 8 is really specific to the non-resident, non-employee director. And they're basically what they're saying, without saying as much, is the benefit of the service provided. Well, the benefit of the service is where where the corporation is headquartered. So it's kind of like, okay, come to California, have your board meetings here. And if your company is based in New York, well, you can hang out here, earn all your income while you're in California as a non-resident, and you're not going to pay any tax in California, even though you're here. But then the reverse is also true. You're in New York, you're on a board, you're a non-employee board member. But if the company that you're working for or providing the service for is headquartered in California, they're going to say that's California source income. Even if you never step foot in
Mhm.
California, that's where they're heading with that. One of the things is, and in SALT, it always seems, especially when you're talking about business, non-business income, where do you allocate it? It's to the commercial domicile. And it seems it's always just assumed that that's like an easy answer. And it's becoming less and less easy as
Mhm.
time goes on, especially with here we are on this call here. We're all in different places. Technology has made it such that so it can be more of an issue as to where the headquarters is.
I mean, we have a
Especially,
lot of clients that have just like, we don't have an office. We don't. Like everyone is remote. The only thing we have is a PO box somewhere that gets literally auto forwarded to our controller's house. So it's not this person's home address that we're putting on a tax return. It's your domicile where your PO box is, even though there's no officer there, there's no management happening.
Right. Where are the books and records?
Mhm.
The internet,
Correct.
At the
Yeah.
cloud.
the
In the
cloud,
cloud. In the cloud. Yeah. I mean, I've had
Headquarters.
that. I've had those questions. Like the accounting team is spread out. They're remote and books are in the cloud. What's the commercial domicile?
Yeah, it's
It's a
difficult.
great question. It's a great question.
And I think the states and California would love to just eliminate that as a thing um, in the allocation apportionment world. Like, we don't like business income at all, for one. And even if it is, and we can't get away from it, let's use this business situs rule. This Metropolis case kind of alluded to that in their concurring opinion, um, which is not the law actually, because they decided the case um, based on a different rationale, but it's just kind of indicative of where it seems to be going. And like to say, hey, if hey, it's non-business income. All right, we're gonna win, and then they come back and go, okay, but we're gonna say that you're commercially domiciled here. Then,
now we get all of
but
it.
really, like, where are the officers who are running the company? That's like the main thing, but like it could be dispersed all over the place.
Right. Right.
Yeah, we also have I mean, it's a little different because this group of kind of entities does have a California manufacturing facility, but realistically, all of their officers are in the UK. Like their CFO, their CEO, realistically, they have one kind of managing director, so it's not chaos in an office, but the board, everyone sits in the UK.
Yeah, you can have a commercial domicile there. Why not? Doesn't have to be in the U.S.
So under sourcing, I mean, again, this entity within a large scale structure is, incorporated in California. So, but you could have completely unrelated board of directors, not even in the US. So now it's nowhere.
Right, right. It's not in California. Not here.
Um, and so and this might also kind of speak to budget, you know, Governor Newsom doing stuff, but California kind of suspended some NOLs again that it's done before. We talked about 2008. I think it did it in 2008, 2011. It does it here, there, everywhere in some capacity.
Mhm.
Um, why do you think California always goes there to kind of that NOL suspension? And, do you have any sort of thoughts on that and just kind of some of those suspension of items, that some states do, some states don't? I think Pennsylvania's realistically got a permanent 60% cap on any NOL utilization. Connecticut's got
Mhm.
some suspension. Colorado did something, I think, back in the day, similar when California did about 2008-ish. Any thoughts on all of that
And
tracking
California has been
nonsense?
they've been using this NOL suspension for quarter century now as part of their budgeting process. It's always when the budget looks dire. This latest version actually gives them an opportunity to reverse it if the right bit the money is in. If things go better, but the prior ones did not. It's just easier. I mean, it's difficult to get a tax increase, even though this is a tax increase. Um, I think it is, but it's easier for them to, and they've done it so many times. I think the problem is that people investing in California are going to be like, okay, there's a good chance we're not going to be able to use our NOL at some point because California it's a cyclical. Wow, we are way above budget. one minute, and then, oh my gosh, we are in catastrophic. Because the revenue California generates from its income tax is like almost all of it is from the one percenters, and almost all of that is from basically the stock market. So stocks go up. You could look at the track NASDAQ and track California's budget. There might be a little lag, but um, there's huge reliance on that. And that's why there's so much volatility. So then in the lower times, and it's like, hey, we need to pay all of these bills we have every year because no matter. So we turn off the NOL faucet, we can get a little bit more money in. And then the theory is you'll get those extra years later. It's suspended, but you're not going to lose a carryover year.
It's like an easy, low hanging fruit for them.
Yeah. Yeah. A way to raise taxes without raising taxes.
Right.
And then it's all, it applies to corps and individuals, but optically it looks like you're getting the businesses and not the little guy.
Mm-hmm.
So yeah, I had a case once in one of these NOL suspension deals where um the client actually, so during the year, one of the years the NOL suspended, but also during that same year they actually incurred an NOL. And so FTB's argument, and they have a legal ruling that says this, is if you weren't able to utilize the NOL, then you don't get an extra year. And statute doesn't say that. The one back in the years I was dealing with doesn't say that. But FTB's legal ruling does. That legal ruling is iffy, questionable, in my view, anyway, of its applicability. So if there are cases where, hey, we needed that extra year and it expired, but we had the suspension, and FTB's like, you don't get the extra year. Well, I think that you do get the extra year. This is 2008 suspension though. So every year, you got to look at every year differently. They tinker with it a little bit, but that's kind of my experience with the NOL suspensions.
Well, because California didn't adopt, or what's California's carry forward period? Is it still limited to 20 years and
It's 20 years now,
but not capped at 80? Right.
not
So
capped at
they
80.
didn't adopt TCJA
No,
80% but unlimited.
they did not.
So you are still having an opportunity for an NOL to expire, where other states kind of adopted the forever carry forward.
Yes. And then California's NOLs, like, gee, over the last 25 years, you could write a book on it as far as like, what are the carryover years? I mean, sometimes it's 5, sometimes it's 10. It's
Mm-hmm.
changed so much. So got to kind of look at each year's rule, and your NOL schedules could be insane with what your carryovers are.
Need a flow chart.
Yeah.
That's the
Yeah.
accountant. That's the accountant 3.
Decision tree. Yeah.
Uh-huh.
Yeah.
I'm sure Illinois could draw you up a flow chart for your
That flow chart doesn't make any sense to me either. So,
no.
which it's going to the wayside, I think now. Anyway, so it's okay.
And then kind of as we wrap, anything kind of on the horizon that you're keeping your eye out that you think California is gonna pick on that we haven't really talked on, or this is kind of like a big, they're gonna start taxing software, right? Like that's the newest, greatest, hottest, latest. Or that's not
Yeah.
true. I'm not saying that, but just something that is something that you're keeping an eye out that I'm all of a sudden I'm quoted for.
Maybe edit that out.
Oh, well, I mean, California, big state, big tax state, right? But they are, unlike the East Coast, they're unwilling to tax technology, really.
Yeah,
Um,
it would be
and look
bad
at the
business,
people in California, you can understand why.
right?
Yep.
Like, we want to keep
Absolutely.
these people here.
Yep.
The big
Yep.
boys have some say in it. So, like, um, SaaS and things like that, I haven't seen much California doing that. At some point, it gets desperate. Maybe they do. So there's one area. I wouldn't say it's new, but emerging, and I think a lot of people aren't aware of it. It's it goes back to UDIPTA and independent contractors. And there was this case, Bindley. I don't know if you're familiar with Bindley. It surprised a lot. Oh, okay. Well, then I got an even better case after that one, since
All right,
you're
let's do it.
all right. So Bindley was a screenwriter, and he was in Arizona. Just lives in Arizona, screenwriter, and he sold his scripts to someone in California. Never filed a California return. He was a sole proprietor. So the screenwriter issued a 1099 to Mr. Bindley, and this is where FTB picks up this market-based sourcing stuff. And hey, you should have filed is the 1099s, and you can see that from the opinions. At least now, they may start finding some other sources, but 1099s are kind of where they're able to identify people who haven't filed. And they identified Mr. Bindley, and this went up to the Office of Tax Appeals. It is a precedential decision. And they said, okay, Mr. Bindley, you owe California tax because market-based sourcing, your customer received the benefit of your service in California, your service being writing transcripts. So there was a case before, which was non-precedential, this appeal of Larson. And in the appeal of Larson, the OTA decided the opposite of this. They decided there was no unitary business going on in California because Larson was a out-of-state person. He didn't come into California at all, perform no services in California. And FTB made the argument about market-based sourcing. They got the 1099, but the OTA said that he wasn't conducting a unitary business in California. And under the regulation, you're not even covered by it unless you're conducting a unitary business. So that was a good case to see. People were happy until Bindley came out, and then people were kind of surprised, a little bit shocked. Like, hey, you're conducting a unitary business in California because you have a customer who's receiving the benefit of the service in California. So now I want to talk about this other case, and they used Bindley for the basis of it. Appeal of Loober, Loober. This will be close to your hearts because this is an out-of-state accountant. This out-of-state accountant, yes, did accounting services. She was in the state of Washington, so there's no personal income tax there. But she prepared returns. She must have done some returns for businesses because that's where you'd get a 1099. And FTB came knocking on her door and said, you need to pay tax for these years. And they applied Bindley. It went to the OTA, non-precedential decision, but I think a tale worth paying attention to. And she ended up getting hosed for all of the taxes. Because of market-based sourcing and 1099s, no penalty abatements. And here's the thing that is really interesting. Like, I think the OTA was making a statement here. I'm gonna pull up the regulation just so I can read it. Pardon me. I want to be exact. I'm wearing this page out. Oh, my vision
We'll send
keeps
you a tax marks bookmark so that every time you open that page, you can see. You can think of us.
Okay, so she gets hit up with, and then in the regulation, it's the 17951-4, income from a trade or business. That's been there for a while, and it's like, hey, you know what? If you've got partnerships and LLCs and whatnot, you essentially, if it's unitary, you need to apply UDIPTA. Then there's 17951-5, and this is what we were talking about earlier about wages, salaries, and other compensation for personal services performed in this state. What it says. They have an example, and it is for lawyers, accountants, and other professionals are supposed to source their income based on where they perform the services. So there's a little conflict here between the two
Sure.
regulations, and the OTA almost. I mean, I don't know. They put a footnote that appellant never raised the question of whether this regulation should apply, which it seems applies directly on its face. She's an accountant. She did not perform, and that's it. Didn't raise it. We're not going to help her out, and we're not going to waive penalties. They're really just saying, hey, we're very serious about these market-based sourcing rules. You've got clients here that you're serving. We expect that you comply with these rules, you file your returns, you pay your taxes. One other thing to note about this issue with independent sole proprietors, really, especially for the smaller businesses, one way to kind of alleviate this concern is to create an LLC or a corporation, because then you get into the factor presence rule.
That was going to be my question, is if, do the factor presence rules apply to humans? And if not, could she have started a business or had the business be paid?
Yeah, so in California, as an individual, if you have California source income of above, it depends on your filing status, like 30,000. I mean, it depends if you're married, filing jointly or whatever, but it's not
a lot.
as generous. No, it's not a lot.
Right.
But if you performed your services with a limited liability company or a corporation, then you can say, hey, we don't have to file here because we haven't exceeded that. And then you're safe from that for the smaller ones. Once you exceed it, then you're kind of in the same mix. But there's a bit of surprise, especially because she ended up having, what was it, like 300,000 for all of the years. Like, she would have been protected if she had an entity, but she didn't.
So I have a question on this though, because you have to have a unitary business in order for those to apply. So is she unitary with herself? I mean, there's the unitary business, basically.
So I
What's
think
the argument there?
Yeah, if you want to read Bindley, you can read it a million times, and good luck finding it. But I think the theory is this: it's because because California adopted market-based sourcing.
Yep.
The unitary business now includes your market.
Gotcha.
I think that's the theory.
Which is right, which is that's where I was kind of what I was wondering. What is she unitary with? The customer, or where her market is?
Her market is
Yeah.
part of the confines of the unitary business includes that, not where you're working. So that's sort of the theory.
That is pretty egregious.
Yeah. Well, I mean, this hasn't been challenged in court yet. This is the OTA.
Sure.
It is a precedential opinion, and that's how it goes. If there's ever a case, then we'll have to see what a court says about it. It could undo all of that. But until then, this is the
right.
law.
But I think, it's a cautionary tale, right?
A cautionary tale. Peels of Loober, Loober. It's worth looking up just to,
especially for those accountants that might be listening to this as well.
Yeah, or attorneys, service providers. It's like, hey, read it before you go to bed if you want to have some nightmares.
Or you're having trouble falling asleep.
Yes. Well, there's no benefit on the other side of it, where it's like, hey, I'm here, but it's like, I'm a resident, so worldwide income is taxed. I don't remember the benefit.
Right.
Well, Michael, thank you so much for your time, for your friendship, your advice, your kind of being a part of our network of friends of the firm. We greatly appreciate your expertise and taking the time to sit with us. I'm sure maybe after another California legislative session, we'll see what happens. Make you a recurring guest based on geographic. So thank you so much for your time. We really appreciate it.
Absolutely.
Thanks, Michael.
Happy to do it. Thanks, guys.
All right.
All right.
Yeah, thanks.
That's another episode of SALTovation. Till next time.